Hello everyone. I welcome all of you to the 57th session of the course Energy Law. In today's session, we will examine waste to energy initiatives in India. Let us quickly recap what we have discussed in the previous session. In the previous session, we examined biofuels in India. We started with the biofuel potential, followed by evolution of India's biofuel policy framework and the regulatory architecture. Then we examined biofuels, energy security and climate change. In the end, we also examined biofuel governance challenges in India. In today's session, we will examine the waste to energy initiatives in India. We start by examining the legal and policy framework. Then we will examine distinct waste to energy projects and models, followed by an analysis of various challenges. In the later part of the session, we will examine judicial and tribunal scrutiny, followed by the Supreme Court's observations on urban waste management. Let us briefly examine the scope and significance of waste to energy initiatives in India's clean energy transition. India's waste to energy potential arises from rapid urbanization, rising municipal solid waste generation, expanding sewage networks, and growing industrial and agro-processing activity. Urban India generates over 150,000 tons of municipal solid waste per day, of which a significant fraction is organic and energetically recoverable. In addition, sewage sludge, industrial effluents, and agricultural processing waste provide feedstock for multiple waste to energy pathways. Key sources of waste to energy potential include municipal solid waste, particularly biodegradable and high calorific fractions, sewage and fecal sludge, enabling energy recovery while improving sanitation outcomes, industrial organic waste from food processing, distilleries and dairies, and agricultural and market waste, especially in peri-urban regions. With this brief introduction on the scope and significance, let us move on to our detailed discussion. Let us examine the legal and policy framework relating to waste to energy initiatives in India. Waste to energy initiatives in India are governed predominantly by environmental legislation and executive policy rather than by a dedicated energy statute. The core regulatory foundation is provided by the Solid Waste Management Rules 2016 along with allied waste rules covering plastic, hazardous and biomedical waste. These instruments regulate waste segregation, collection, processing and disposal, which are prerequisites for any viable waste to energy project. In parallel, the Electricity Act 2003 enables grid-connected power generation from waste, allowing waste-to-energy plants to participate in the electricity system, subject to state regulatory approvals. Policy support for waste-to-energy flows from multiple sources, including MNRE programs promoting waste-to-energy, biogas, and compressed biogas through capital subsidies and technical guidelines. The Swachh Bharat Mission and broader urban sanitization policies, which emphasize scientific waste processing and reduction of landfill dependence. And state-level tipping fee frameworks, feed-in tariffs, and power procurement policies often notified by state governments and electricity regulators. The waste-to-energy facilities are typically embedded within municipal concession agreements or public-private partnership contracts. As a result, local governance, contract design, and municipal capacity play a decisive role in project viability. Let us examine distinct waste-to-energy projects and models in India. India's experience with waste-to-energy demonstrates a range of project typologies, each involving different technologies, institutional arrangements, and legal risk. These models highlight how governance challenges vary depending on scale, feedstock, and contractual design. Let us examine the municipal solid waste incineration plants. Grid-connected municipal solid waste incineration plants are concentrated in large metropolitan areas where waste volumes are sufficient to support scale-intensive projects. Such plants rely on long-term concession agreements with urban local bodies, which assures water supply, tipping fee, and power purchase agreements with distribution companies. Frequently, disputes arise over waste quality and calorific value, particularly due to poor segregation. Performance obligations of municipalities, including minimum waste supply guarantees, and tariff adequacy and payment security, affecting project bankability. These issues often lead to arbitration or litigation, underscoring the importance of robust contract design and risk allocation. The second category is that of refuse-derived fuel facilities. RDF facilities convert segregated waste into fuel used primarily by cement kilns, and industrial boilers. These projects operate at the intersection of waste management law, industrial emissions regulations, and private contracts between municipalities, operators, and end users. Their legal relevance centers on classification of RDF as fuel versus waste, compliance with environmental and emission standards, and enforcement of segregation obligations at the municipal level. RDF projects demonstrate how downstream industrial demand can improve waste to energy viability but also complicate regulatory oversight. The third category is sewage to energy and sludge-based biogas projects. Energy recovery from sewage treatment plants and sludge-based biogas systems improves plant efficiency and reduces methane emissions. These projects raise governance questions concerning ownership and monetization of energy output, eligibility for renewable energy tariffs and incentives, and coordination between urban water utilities, municipalities, and electricity regulators. The absence of clear rules on energy rights within water infrastructure often creates regulatory uncertainty. The fourth category is industrial waste to energy projects. Industries such as food processing units, distilleries, sugar mills and dairies increasingly deploy captive biogas and cogeneration systems using process waste. While these projects benefit from regulatory exemptions and self-consumption models, they face challenges related to grid interconnection standards, sale of surplus power or gas, and eligibility for renewable energy certificates or other incentives. These issues highlight the limits of existing framework designed primarily for grid-scale power. The fifth category is decentralized organic waste to biogas systems. Small-scale biogas units serving markets, institutions, hotels and housing complexes represent the most decentralized waste to energy model. Although environmentally beneficial and aligned with circular economy goals, they often remain outside formal energy planning. Key challenges include regulatory ambiguity regarding licensing and standards, lack of access to mainstream project finance, and limited integration with municipal waste strategies. These systems illustrate the need for lighter, clearer regulatory frameworks tailored to decentralized and community-scale waste to energy solutions. Now let us examine the challenges relating to waste to energy initiatives in India. Waste to energy projects in India have frequently faced public opposition, particularly at the local level, driven by concerns over air pollution, odor, health risk, and siting near residential areas. Such resistance reflects broader governance deficits, including inadequate environmental impact assessments, limited public consultations, weak disclosure of project data, and low levels of trust between municipal authorities, project developers, and affected communities. From a legal standpoint, disputes surrounding waste to energy projects commonly invoke environmental clearance and consent norms, especially compliance with EIA requirements and emission standards. Municipal accountability, focusing on waste segregation, contract enforcement, and public health responsibilities. The public trust doctrine, under which natural resources and environmental quality are held in trust for the public, and judicial scrutiny of technology choice, including the appropriateness of incineration vis-a-vis alternative waste management options. Courts and environmental tribunals have increasingly emphasized source segregation, recycling, composting, and non-incineration alternatives as prior obligations before resorting to energy recovery. This jurisprudence has narrowed the contours of waste to energy development, reinforcing the principle that waste to energy should function as a last resort within the waste management hierarchy rather than a substitute for effective waste reduction and segregation. Let us examine the judicial and tribunal scrutiny of waste to energy development in India. Waste to energy projects in India have been subject to sustained judicial oversight, particularly by National Green Tribunal, reflecting persistent concerns over environmental compliance, public health, and municipal governance. These cases demonstrate that waste to energy is legally contested terrain rather than a settled renewable energy pathway. Let us examine the Okla waste to energy plant dispute. The Okla waste to energy plant, located near residential areas in Delhi, became one of India's most litigated waste to energy projects. Residents and civil society groups challenged its environmental clearance and operation. Key legal issues include adequacy of environmental impact assessment, compliance with emission and air quality standards, siting of incineration facilities near habitations, and consistency with solid waste management rules. The National Green Tribunal acknowledged the policy legitimacy of waste to energy, but stressed that energy recovery cannot override environmental and public health safeguards. The Tribunal imposed continuous monitoring requirements and emphasized segregation of waste as a precondition for sustainable waste-to-energy operation. Let us examine the dispute concerning Ghazipur and Balswa waste sites. While primarily landfill sites, proposals for waste-to-energy conversion at Ghazipur and Balswa triggered litigation due to safety hazards, fires and pollution. Key legal issues include municipal failure in waste management, prioritization of waste reduction and segregation over incineration, and environmental liability of urban local bodies. The municipal authorities were criticized for treating waste-to-energy as a substitute for systemic waste management reform. The Tribunal reiterated that waste-to-energy is the last option in the waste hierarchy after segregation, recycling and composting. We can see that these cases reinforced the waste hierarchy principle as a binding normative standard in waste-to-energy governance. Further, the revival of the Timarpur plant as part of an integrated waste-to-energy complex attracted challenges regarding technology choice and environmental performance. Key legal issues include legacy technology risk, contractual obligations of municipal authorities, and consistency with evolving waste management standards. Judicial bodies emphasize that technological obsolescence cannot be shielded by legacy approvals and that waste-to-energy projects must comply with current environmental norms, not historical standards. Again, significant is the Chennai and Hyderabad waste-to-energy litigation. Proposed operational waste-to-energy plants in major cities faced legal challenges concerning environmental clearance, order, ash disposal, and public consultations. Key legal issues include procedural compliance with environmental clearance, adequacy of public hearings, and ash handling and secondary pollution. The National Green Tribunal stressed that procedural compliance is substantive and failure in consultation or monitoring can invalidate otherwise policy supported projects. Let us examine Supreme Court of India's observations on urban solid waste management. Although not always directed specifically at waste-to-energy projects, the Supreme Court's jurisprudence on municipal solid waste management has had a significant indirect influence on waste-to-energy governance. Through a series of public interest litigations, the court has consistently framed waste management as a matter of constitutional responsibility and urban governance rather than a purely technical or contractual function. Key observations include The constitutional duty of municipalities under Article 21, right to life and clean environment, read with Article 243W, which entrust urban local bodies with functions relating to public health, sanitation, and environmental protection. Another significant observation is regarding the application of the public trust doctrine, requiring state authorities and municipalities to manage environmental resources, including urban land and air quality, in the interest of present and future generations. Also important is the accountability for environmental degradation, with courts emphasizing that administrative inefficiency or financial constraints cannot justify continued environmental harm. These constitutional principles have been increasingly invoked in waste to energy related litigation, to scrutinize project approvals, siting decisions, and municipal performance. As a result, waste to energy projects are assessed not only on technological or economic grounds, but also against constitutional standards of governance, transparency, and public health protection. This reinforces the view that waste management is a core public obligation rather than merely a service delivery arrangement. Now let us summarize the key takeaways. Indian courts and tribunals have consistently held that waste to energy is permissible but not preferred over waste reduction and segregation. Renewable energy status does not dilute environmental compliance. Municipal contracts and concessions remain subject to public law scrutiny, and local participation and transparency are integral to project legitimacy. Let us conclude our discussion. Waste to energy jurisprudence demonstrates that renewable energy law in India operates within a hierarchy of environmental norms. Unlike solar and wind, waste to energy projects are embedded in urban governance failures and therefore face higher litigation risk. Courts have effectively positioned themselves as arbiters of last resort, ensuring that energy recovery does not become a justification for environmental shortcutting. Let's see what's coming up. The upcoming session will explore green hydrogen as a key clean energy vector, focusing on renewable based production, India's national green hydrogen mission, and its role in decarbonizing industry, transport, and energy systems. Thank you.